Yes.
May I seek your lordship indulgence in mentioning item number 7, my lord?
Yes.
My lord, I'm appearing on behalf of Mr. Sizoram Chana. Due to personal inconveniences, we would like to take adjournment. We've already taken consent from petitioner's side also.
I'm standing right next to you.
Yes, my
What do you
lord.
say?
Yes, last night, yes, he contacted me last night. There's a problem with him, Lordship.
Okay. When do you want it?
Maybe after vacation, Lordship.
A mention has been made on behalf of Mr. Sizoram Chanallanet, Standing Counsel, Mizoram Rural Bank, appearing for the respondents, to the effect that he has some personal difficulties to appear before the court today, and therefore the matter may be adjourned. So Mr. T. Lanunciama, Lanet Counsel for the appellant, has no objection to the prayer. Stop in view of above. Let the matter be listed after the ensuing winter vacation, as paid for.
Oblak Lordship.
Much obliged.
For orders, item number 4.
Lordship, as per this Honorable Court's order dated 6/9/2024, this Honorable Court has directed the state government to set up a Human Rights Commission. And Lordship, I have received a letter and there's a notification issued. And the same has been complied with, Lordship. The notification is dated 11/10/2024.
Who is one? Isiami? Oh, she's the one. Okay. So what is the next step now?
Next step, Lordship, at this stage, as per the instruction I've received, they're still searching for the building, and proposal of the chairperson and the member has been made by both the petitioners and the state government also. It's still under process, Lordship.
Yes, what do you say?
Yes, Lordship, we have submitted our proposal. ZW has submitted our proposal on 10th of October 2024 for the chairperson, member, PS2 chairperson, and secretary. If I may given allowed to submit the affidavit for the proposal we have submitted.
No, that's okay. So that's for them to take a call.
Yes,
Whom
Lordship.
to appoint, whom to select. We're not concerned with that. It may be any individual, XYZ. But the thing is that since the constitution has been done, so the process of appointing somebody and making the commission work is the step to be taken. Now, how long that should take to complete the process of selection and establishment of the, because not only the chairperson, there will be other members also.
Yes, Lordship.
How many members are required? 2 members.
Chairperson 1, member 2.
2 members. Then the second notification provides for the kind of staffs and the that's required.
These are all approved by the state government, Lordship. 16 posts has been approved by the state government.
No, that's right. It's good. It's approved, but this is basically a paperwork. You have to put that in
Yes.
in place.
It will take some time, Lordship.
So that's what we wanted to know. How much time should it take?
I can get some instruction, Lordship, with regards to that.
Okay, yes. Inform of an affidavit.
Please write down. Miss Rosalind Elmar, learned counsel for the petitioner, is present. No, you start like this. You cancel that. Heard Miss Rosalind Elmar, learned counsel for the petitioner, and Miss H. Lalmal Swami, learned government advocate, appearing for the respondents. Stop at the outset. Miss H. Lalmal Swami, learned government advocate, by producing two notifications, both dated 11/10/2024. Informs the court that the order dated 6/9/2024 has been complied with. Stop. A perusal of the notification. Perusal of the notifications goes to show that the Mizoram State Human Rights Commission has been constituted by the state government under the provisions of section 21 bracket 4 and bracket 1 of the Protection of Human Rights Act, 1993, with its ITS, its headquarters at Aizawl. Stop. The other notification is in respect of creation of (16) posts, which includes chairperson, 2 members, officers and staffs for the new establishment. Stop. Next para. The learned government advocate submits that the respondents are in the process of considering the appointment of suitable persons as chairman, public chairperson, and members of the commission, apart from looking for an appropriate building to house the new establishment. Stop. She submits that the said process will take some time. And therefore, court may grant the respondents some time. Next para, Miss Rosalind Elmar, learned counsel for the petitioner, also submits that the petitioner has submitted a proposal to the state government for appointment of the chairperson and the other two members of the commission for their consideration. Stop. Next para. Having regard to the aforesaid development, we have noticed that some positive steps have been taken by the state respondents in furtherance of the establishment of the Human Rights Commission in the state of Mizoram. Stop. However, it goes without saying that there are you cancel that. Further, it goes without saying that the state respondents will have to take further steps to establish the commission by appointing suitable persons as its chairman slash chairperson and members, apart from filling up the posts which have been created. So that the commission can be set in motion. Stop. Next para, in view of above, we deem it proper to adjourn the matter. So we have a date. For 8 weeks. Stop. In the meantime, the respondents shall file an additional affidavit incorporating the notifications which has been produced today and also inform the court all the steps taken for establishment of the commission pursuant to the issuance of the said notifications dated 11/10/2024. Stop. The matter shall now be listed on a date to be fixed by the registry after a period of 2 months. I think we'll retain a copy of this notification also.
Yes, yes, Lord.
The two notifications produced by the learned government advocate is being retained in the record and marked as X and Y for identification.
Obliged, Lordship.
Item number 2.
Your Lordship, when the matter was last listed, I had informed the court that there were details which were requested from the concerned DFO. In this regard, Your Lordship, just yesterday I received a copy, and so I will receive the actual hard copy by this week probably. So if 2 weeks time may be granted to file the affidavit, Your Lordship.
Another 2 weeks, court will be closed.
Your Lordship, the matter may be heard on the 11th December.
Okay. Parties are represented by the respective counsels. Stop. Ms. Lalnun, Louis Learned Government Advocate, appearing for the respondents, submits that she will be receiving the instructions required to file the additional affidavit during the course of this week. And therefore, she prays that matter be posted again after 2 weeks. Stop. In view of above, that the matter will be set on 11th of December, 2024.
Much obliged.
Obliged.
Item number 3.
My lord, this is for have to come up with a concrete proposal for execution of works of district of jails in Mizoram. In this regard, my lord, I have received some instructions. However, my lord, the concrete instructions cannot be received till date because the funds are not yet received from the ministry, and the actual implementation of work will take place only after the funds are received. For now, my lord, the Home Department has already taken up identification of the detailed items of works which is required, and thereafter, my lord, the project will be transferred to the PWD department. And we have the next step will be the preparation of DPR, the technical vetting of DPR, administrative approval and expenditure sanction, and thereafter only will be floating tender and other procedures will be taken up after actual execution of the work.
We would like to see that in affidavit by way,
Yes, my lord.
by way of an
I'll
affidavit.
file my affidavit, my lord.
Now, one thing, see, the fund has been sanctioned on what basis? Any such kind of project proposal has been made? On which basis the fund has been allotted? Or simply just some fund is allotted like that, and from there you have to somehow figure out how to utilize it?
The fund was, my lord, coming from SOT scheme.
No, that's right. From whatever source it may be.
Yes, my lord.
Whenever some fund is sanctioned, there's a purpose for that.
Yes.
And to serve that purpose, some estimate, some project is presented, on which basis the funds are sanctioned generally. So what is the situation in this case?
My lord, in this regard, we have,
How this 55 crores have been worked out?
Lordship, as per 16/7/2024, the state has already mentioned that it will be for the sanction of construction and upgradation of jail.
That's right. See, what I meant was,
my lord, I have received instructions that the government of Mizoram had taken advantage of the scheme of SASKI, and this amount of 55 crore was allocated to Home Department for construction of Central Jail and seven district jails.
how much will go to which jail, and all those things are not been worked out?
Yes, my lord.
You have to organize how much fund will go to this jail. There are how many jails? 7
That we
jails.
have already identified, my lord. The
so we-
department, the home department has already identified.
So we would like to see those details.
yes.
That is why we had granted you time to file an additional affidavit. So what is happening in the air? Jail construction. There
As
are-
per
there
one
are-
prominent newspaper of online, Your Lordship, the Home Minister has stated that Champai is going to be renovated.
Only
That,
Champai.
yeah, only Champai, yes, Lordship.
What about the other places?
They have not mentioned the other places, Lordship.
So this amount should cover 7 jails according to the
Yes,
state.
You have found an affidavit. Where this, oh, well, but this was too.
It's too sketchy, you know. Actually, you quoted past some. If you go through the order passed on 6/9/24, there was a recording that we expect the state government shall come with concrete proposal for execution of the works for improving the conditions of prisons as per the assessment made by it. Four weeks time is granted to clarify the proposed work for improving the conditions of prisons. And it's started by which date and to be completed by which date? Haven't they worked out the schedule?
My lord, we have only the overall abstract of cost. We
That was in
expect
the
state
affidavit.
government- Yes, my lord.
Additional affidavit filed by you was just 1 page next year.
My lord, out here in the order, it's written, we grant 4 weeks' time to the state to clarify when the proposed work for improving the conditions of the prisons in the state of Mizoram is scheduled to be started, and by what time it would be completed. This is what I was answering, my lord. We have not, this fund has not yet been released. Not yet. So we cannot say regarding the time when we are starting the work. However, my lord, we have already identified, and the
Who will-
project will be given
Who will release it, when they will release it?
by the ministry.
So what is the steps taken by you? You tell us. If you need the assistance of the court, tell us that this is the ministry or that is the ministry which is supposed to release the fund. We can look into that.
My lord, the ministry has not yet released any funds for Saski under 2024 to 2025.
Okay, so how do you work out this sum of 55 crores? Supposing you're getting 100 crores through Saski. Out of that, you've just apportioned 55 crores, which will be received, will be made use of for improving jail. Is that how you have worked out? Or from the source of the fund, it has already been chalked out that
It has
55
already been
crores?
chalked out, my lord.
Okay. How it has been done, you show us. That's what we are asking you. Your annexure to your additional affidavit at page 5 shows the 8 locations of prison, number of works to be executed, total amount to be utilized. Maximum goes to Central Prison, Aizawl. Second is Siaha. How have you worked out this? What are the details? This is only an abstract of the cost.
My lord, I have in detail. I'll file my affidavit in this regard.
Why didn't you file if you have in detail beforehand?
I have received it recently, my lord.
Recently can be January also.
No, my lord. Like I've stated in the last court date, the file was engaged with the department.
So when can you file it?
2 weeks time, my lord.
Before the vacation?
Yeah. Yes, my lord. I can file it before the vacation.
We'll list it on 11th again. The one matter is being listed. So you can take it up on that.
Wednesday. All right, my lord.
Parties are represented by their respective counsels. Ms. Linda L. Fumble, learned additional AG, submits that she has received the instructions required for filing additional affidavit. But however, prays for 2 weeks' time since the same was received recently. Stop in view of above. Matter will be listed again on 11th of December 2024.
Obliged, Lordship.
For hearing, item number 5. For hearing, item numbers 1 and 2.
Yes.
In fact, Your Worship, I had finished my part on the last court day. My learned friend, appearing on behalf of the private respondents, I think was just going to submit.
Can you just quickly recapitulate just the
Your Worship,
basic points? Manghak, you may go.
the basic grievance of the petitioners was that they are promotees. And according to the 2002 amendment of the MCS rules 2000, 2/3 of the vacancy is to be filled up by direct recruitment and 1/3 by promotion, induction. And on 9th of August 2010, the respondent number 2 had initiated the process of direct recruitment as well as induction by way of promotion by sending a letter to the respondent number 3, stating that the government had decided to fill up 15 vacancies, out of which 10 were to be filled up by direct recruitment and 5 by promotion. That was the requisition sent on 9th of August 2010. Then the MPSC had issued the notification, which was in fact an advertisement on 19th of November 2010, whereby the respondent number 3, MPSC, had notified that they were going to fill up 5 posts of junior grade of MCS by induction, and they had called for willingness from the eligible officers, and willingness had to be submitted before 16th of January 2011. Accordingly, Your Worship, the petitioners had all submitted their willingness before 16th of January 2011. However, subsequent to that, the respondent number 1 and 2, by letter dated 22nd of March 2011, had informed the respondent number 2, since the department was making new MCS rules, until the new MCS rules were made, the process of induction should be stalled. Again, on 10th of May 2011, the respondents number 1 and 2 had again informed the respondent number 3, that MPSC, that the proposal for filling up of 5 vacancies by way of induction should be stands cancelled. So, but that order, the letter dated 22 March 2011, as well as 10th of May 2011, stalling and then cancelling the process of induction, was challenged before this Honorable High Court by way of writ petition number 127 of 2013. And accordingly, the writ petition number 127 of 2013 was allowed by judgment and order dated 23rd of September 2014, whereby the Honorable High Court had set aside the 2 letters stalling as well as cancelling the process of induction, and had directed the state respondents to consider the case of the petitioners therein in accordance with the 2002 amendment rules. Accordingly, the petitioners were inducted into the junior grade of MCS on 15th of January 2015. Thereafter, Your Worship, a seniority list was prepared by the respondents number 1 and 2 on 4th of September 2015. And then again, there were 2 provisional seniority lists dated 3rd of October 2017 and 24th of April 2018. And subsequently, in spite of the representations being filed against the provisional seniority list, the impugned seniority list, final seniority list, came out on 21st of June 2018. And whereby the present petitioners have been interspaced between the private respondents who were directly recruited on 15th of January 2015. And our case is that the initial requisition, which was issued in 2010 for filling up of 10 posts of direct recruits along with 5 posts of promotion had culminated in the appointment of the private respondents number 4 to 12 in 2012. So our case is that our seniority should be interspaced with those respondents number 4 to 12 who were directly recruited in 2012. That is 16/4/2012. Because our process of recruitment was initiated on the same date. That is in August 2010.
The impugned seniority is a notification dated 21st of June 2018
Yes,
at page 77.
yes.
This petitions are at page 80. Then private respondents 10, 11, 12 are at page 78. Where are the rest?
Pardon, Your Worship?
The private respondents, where are the names?
All the private respondents.
Yes, how many private respondents are there?
Forty-seven. The problem came, Your Worship, after cancellation of the induction process. The state respondents, in violation of the recruitment rules, service rules, carried on direct recruitment without going for promotion by way of induction. So there were a lot of direct recruits who were appointed by the respondents without conforming to the rules. They ignored, totally suppressed the promotion quota. And although the rules clearly stated that 2/3 have to be filled by direct recruitment and 1/3 by promotion, they ignored the 1/3 promotion quota and they carried on recruiting through direct recruitment on 2-3 occasions. That is why there are so many private respondents. We have been interspaced with those who were directly recruited in January 2015. But between 2012 and 2015 January, there were about 25 direct recruits. So we have made them all respondents.
So in all, there are 50 respondents
Yes.
in this
Pri-
WPC.
Respondents number 4 to 50 are private respondents.
So where does their name figure in the seniority list?
The respondents,
Private respondents.
it starts from number 1, Your Worship.
1 is respondent number 10,
Yes.
2 is number 11, 3 is 12.
Yes.
Then remaining? Because I had just marked this three respondents.
Your Worship, 13, respondent number 13 is at serial number 4 at page 78.
Okay. Then
Sorry, respondent 13 is serial number 4. Serial number 4 at page 78 is respondent number 13. Number
30, 30,
13.
13, okay. He has been appointed to the present grade on 6/6/2003.
These are promotees. Sorry, Your Worship. We are concerned with the direct recruits.
Yes, that's fine.
Banlal Sonoma. Serial number 7 at page 78 is respondent number 15. Serial number 8 is respondent 16. Serial number 9 is respondent 17. Serial number 10 is respondent 18. Yeah, but I'll give the details. Yeah. So all those who were appointed in between 2012 and 2015 by way of direct recruitment have been
Placed above you.
placed above us. Our claim is that since the requisition process for direct recruitment and promotion started in 2010, and it was due to the illegal action on behalf of the respondents, number 1 and 2, in cancelling the induction process, and subsequently in directions of this Honorable Court, it was resumed, and we were appointed in 2015. The delay in our induction was due to the illegal action of the arbitrary action of the respondents. So our seniority should be counted from the date when requisition was sent for direct recruitment in 2010.
So you should be interspaced alongside serial number 1, 2, and 3.
Yes,
That is your claim.
that is our claim. Because these persons were appointed in 2012, but the requisition process started in 2010 August. The same date, our requisition process had also started.
Now, there are 5 petitioners
Yes.
in this WPC. What is the number? 127.
Yes.
Now, in the other writ petition,
There are 2.
there are 2. What is the difference?
The difference is, Your Worship, like I said, the state respondents had totally ignored the promotion quota, and they carried on recruiting by way of direct recruitment. So the respondents in the second case also had approached the Honorable High Court by saying that the action of the respondents in appointing only by way of direct recruitment to the junior grade of MCS, ignoring the promotion quota, is illegal. And in that case, the respondents had stated that on 4/7/2000, on 4/6, at this stage it is important to state that the 2013 rules had come out into the 2012 amendment rules of MCS were published in the Gazette in 2013 March. So there were a number of vacancies which arose before the 2012 MCS rules came into force, and the Honorable High Court had directed that those vacancies which arose before the 2012 MCS amendment rules came to force should be filled up in accordance with the 2002 rules. And as per the affidavit in that case, there
In
were
which case?
the second case here.
No, you said as per the direction of the court. In which direction, in which case?
In direction of the court,
Is it the second round? WPC 95 is the second round.
no, Your Worship, in WPC of 95, in WPC of 95, Your Worship, the recruitment was based on the judgment of the Honorable Court in WPC 44 of 2015. In this present writ petition, we have not annexed the judgment.
44 or 15?
Yes, that is in the second case. We have not annexed it in this case. Your Honor. That is relevant for the second case.
That the order which you have annexed here is a different case.
Yes. In the present case, we have annexed the judgment of the Honorable High Court in WPC 127 of 2013.
Correct, 127.
In this case, Your Worship, the Honorable High Court has set aside the cancellation of the induction process and directed
To complete the process.
to complete the process.
They've completed to you, but they've given you the benefit from 2015.
15. Our case is that we should be given benefit of seniority with effect from 10 August, when the process was initiated along with the direct recruitment process.
Okay, so in the second case, is it like that 2012 covers your case also?
Yes, because in that case, they had admitted in the affidavit that as on 16th of April 2012, while the 2002 MCS amendment rules were still in force, there were 27 vacancies. So out of 27 vacancies, one third, that is 9 vacancies, would be for promotion quota. So the Honorable High Court had directed them to fill up the 9 posts by way of induction, as per the 2002 rules.
You have also annexed WPC 127 order
In the other case,
in the second case.
in the second case.
You were just talking about WPC 44. Where is that?
And that is in the second case at page 103. I think, Yojiba, it's better we finish hearing WPC 127 of 19 and then come to the facts of the other case. Otherwise, it will be a bit confusing.
You have clubbed it together.
But yeah, the law is the same, only the facts are a bit different. The dates are a bit different.
No, so you tell me what is the difference?
The difference is, Your Lordship, if Your Lordship will see, in the second case, page 103, the judgment, WPC 44 of 2000.
This also was filed by the present petitioners.
No. Not by the present petitioner.
Okay. So why have you annexed it?
No, because, Your Lordship, the present petitioners were inducted on the basis of this judgment.
What does it say, the judgment?
If I may take Your Lordship,
It is unlike 127.
there's a slight difference. Because in that earlier the earlier case, the induction process was already initiated and then cancelled. Here, they had ignored the quota for promotion and they had carried on recruitment through direct recruitment process. So, the petitioners herein had claimed that the vacancies under the 2002 rules should be filled up in accordance with the 2002 rules, meaning 2/3 by direct recruitment, 1/3 by vacancy, by
Okay.
promotion.
Okay, WPC number 44 or 15.
Yes.
This seems to be a case of inspector of tax.
No, yeah. He was in the feeder grade. And
Oh, I see.
And he was eligible for induction.
An inspector of tax can be inducted into MCS.
Yes. Yeah. Group B post. And in spite of their being eligible, the process of induction was not carried out by the state. That is why they had approached the High Court due to stagnation faced by them. And if I may take a lordship to para 5.
Yes.
Insofar as the vacancies available, as your lordship got it?
Yes.
Insofar as the vacancies available prior to the amendment of the rules in 2012, Mr. A.R. Malhotra makes reference to the affidavit in opposition filed by the state respondents. It may be noted that at paragraph 9 of the said affidavit in opposition, the state respondents had fairly disclosed that as on 16/4/2012, there were 27 vacant posts in junior grade. Having regard to 1/3 of the 27 vacancies, at least 9 posts were available for being filled up by promotion. Then at para 6, Your Lordship, we had relied on the case of Kulwant Singh, that the vacancy should be filled up in accordance with the rules in force on the date of vacancies. And para 8, Your Lordship. Without going into the nitty-gritty of the case, the foremost point for consideration is whether the 9 vacancies, being 1/3 of the 27 vacancies posts, can be allowed to be filled in terms of the amendment brought about in the year 2012. The answer to this question can be had from the aforesaid case of Kulwant Singh, which lays down that the vacancies occurring prior to amendment of the rules have to be governed by the provisions under the old rules. In that view of the matter, the 9 vacancies which are required to be filled up by selection from amongst the officers in the rank of gazetted posts and working in substantive capacity must be filled up in terms of Rule 8B of the MCS Amendment Rules 2002. Para 10. In view of the clear prescription of law, the vacancies which were available prior to amendment of 2012 has to be filled according to the old rules, which is the MCS Amendment Rules 2002. In the facts and circumstances of the case, a direction is made to state respondents to fill up the said vacancies from amongst officers holding gazetted posts for recruitment to the service in junior grade. It is made clear that in the event the petitioner comes within the zone of consideration, his case for selection and promotion shall also be duly considered. Exercise of recruitment to the service in junior grade in terms of MCS Amendment Rules 2002, as indicated above, shall be completed by the state respondents within a period of 4 months from today.
Coming back to paragraph 5. As on 16/4/2012, there were 27 vacant posts.
On 16/4/2012, Your Worship, I'll read para 3. This will make it clear. Para 3.
Yes.
The said rules had undergone further amendment by means of MCS Amendment Rules 2012, wide notification dated 21/3/2013. However, in terms of the said notification, the same was given effect to from the date of publication in the Mizoram Gazette, that is 28/3/2013. In terms of the said amendment of 2012, proportional prospects for Group B gazetted officers have been taken out. 20% of the total sanctioned posts were kept open for being filled up by selection from amongst officers holding Group A posts. So, Your Worship, in 2012, in fact, which came into force with effect from 28th of March 2013, there was another amendment of the 2002 amendment rules. And according to the 2012 MCS amendment rules, 80% direct recruitment, 20% from officers holding Group A posts. But we had filed the case saying that the vacancies which were proposed to be filled up by the respondents was against the law, because those vacancies which fell vacant before the amendment have to be filled up in accordance with the pre-amendment rules.
Yes, I understand.
So they had admitted in the affidavit that during the 2002 MCS amendment rules, there were 27 vacancies. And that means out of which 1/3 means 9 posts were to be filled up by way of induction.
So, what about the relation to this other case? This the other case, the
Yeah.
WPC 127.
Yes.
The promotion was initiated as per the information given on
2010.
9/8/2010.
So there's a slight difference in the
This is
facts of
prior.
the case. Yes.
So the calculation of the vacancies is correct in this case?
Yes.
10 and 5.
Yes.
There were 15 vacancies.
There were 15 vacancies. They initiated the process of induction by way of promotion for 5 vacancies, which was cancelled. Which was
There were 15 vacancies as on 9/8/2010.
Yes.
So as per the prevailing MCS amendment rules of 2002. So it's 1/3.
Yes.
So taking 5 out for induction, 10 for direct.
Yes.
Then the process was initiated in 2010.
Yes.
Whereas in the second case, it is the case that as on 16/4/2012, before the amendment came into force,
Yes.
there were already 27 vacant posts.
Yes.
However, they were trying to fill it up as
By-
per 80/20
Yes.
by the
Direct
new
recruitment, yes.
amendment. So, this court held that if you go by the old rules, the breakup would be 9 posts will have to be filled up by way of promotion.
Yes.
So, since the vacancy occurred at the time when
Old
the old rules were prevailing, so vacancies have to be filled up in terms of the old rules.
All rules.
So, accordingly, it was filled up.
Yes.
Then the petitioners were appointed.
Yes.
These two petitioners.
Yes.
Now, what is their grievance?
Their grievance is that, Your Worship, since the vacancies were prevailing during the 2002 rules, and we should be interspaced with those direct recruits who were appointed during the 2002 direct recruits.
2002
2002 rules.
rules. Okay. Now,
But they have interspaced us with the direct recruits who were appointed as per the 2012 amendment,
okay. When were we ultimately appointed?
2016.
Where's that page?
Page 113.
Okay, this is your appointment. In compliance of the judgment, and where's the seniority list?
The final is at page 158.
And where's your name? H12 Shoy. Serial number 61. P1
61 and 64.
and P2. So, according to you, vacancy happened
2012.
in 2012, but your selection appointment happened only in 2017.
60 December.
Sorry, 15 December 2016. So, you should be placed amongst those appointed in 2012.
12.
Who are they? Starting from serial number
I'll just.
after 7, 8, after serial number 7, perhaps, of the seniority list. Serial number 7 was appointed on 5/12/2012. Direct.
The 2014. Those who were appointed in 2014.
14. Who are supposed to be your batchmates? 2014.
No, their process was initiated in 2012.
What is that process? What is the next check?
I'll just stay on. Para 21. Committee on Para 21 of the. If I may read Para 21.
Yes.
Respondent number, in fact, this should be respondent number 2, DPNR, had issued a notification dated 3/10/2017, provisionally fixing interstate seniority of officers in the junior grade of MCS, annexing a provisional interstate seniority list thereto, whereby seniority position of the petitioner was interspaced with officers who were directly recruited in 2017 and appointed on 16/1/2017 in terms of the MCS Amendment Rules 2012. Even though the petitioners were selected in accordance with the MCS Amendment Rules 2002, against the suppressed, underreported corresponding one-third vacancies of promotee quota of the recruitment process initiated for the year 2012-2013, in terms of which the instant private respondents 4 to 16 and two other persons, namely Lal Himpui Ralte and H. Zunumma, were appointed by way of direct recruitment, white number so-and-so dated 15/1/2014.
So the process was initiated in 2012, 2013.
Yes.
But there's nothing, no document to show that process. Annexure 32 is at page 135. This is a this is a seniority provisional seniority.
And if I may take your lordship to para 29. Para 30 at page 23.
Para 30.
Yeah, 30, page 23. While considering the case of the petitioners in the light of the OM dated 4/3/2014, it can be concluded that, based on para 5B of the OM, rotation of quota system between promotees and direct recruits for determination of seniority still operates as per OM dated 7/2/86 and 3/7/86.
Okay, what are these OMs?
OMs are, Your Worship, which we had already considered in the previous case also. The OMs which were considered by the Honorable Supreme Court in NR Parmar's case, which had held that rotation of vacancies, rota quota has to be followed. Even though the date of appointments will differ.
OM dated 4/3/2014.
Yes.
And how does it differ with the OM dated 3/7/86?
No, Your Worship, the Honorable Supreme Court in NR Palmer's case had upheld these OM dated 7/2/86 and 3/7/86. And on the basis of NR Palmer's judgment, the OM dated 4/3/2014 was issued by the central government. It's a repetition of what was in the earlier OMs. What I'd like to read, Your Worship, is since the petitioners, has Your Lordship got it?
Yes.
Since the petitioners are appointed on in 15/12/2016 against one-third promotee quota of vacancies pertaining to the year 2012-2013, wherein the corresponding recruitment process for two-third direct recruitment quota was initiated in the office file on 5/11/2012 and requisition sent to MPSC on 31/1/2013 and finally filled up on 15/1/2014. The promotees who were actually appointed in 2016 shall be treated as deemed available for recruitment year 2012-2013, along with direct recruits who were appointed on 15/1/2014. So the direct recruits, the process of requisition for filling them up had started by sending the requisition to MPSC on 31/1/2013. That is during the 2002 amendment rules. So our case is that since the vacancies which we have filled up also were available during the 2002 amendment rules, so the process, the requisition which was sent on 31/1/2013 will apply to us also. Because if Your Lordship will see the OM 4/3/2014, on basis of which the seniority has been fixed, it clearly states 5F.
Dated?
The OM dated 4/3/2014.
Yes, 5F.
5F.
The initial date, the initiation of recruitment process.
Page 131. Page 131. The initiation of recruitment process for any of the modes, with direct recruitment or promotion, would be deemed to be initiation of recruitment process for the other mode as well. And in fact, Your Worship, the reason why the petitioners in the second case were belatedly appointed was due to the arbitrary action of the respondents in withholding the promotion quota. Although the rules clearly stated that 2/3 will be by direct recruitment, 1/3 by promotion. But they carried on filling up the vacancies by way of direct recruitment, illegally suppressing the promotion quota.
Since when?
2012, 2010, August 2010, in the first case. After that,
In the second case, 2012,
yes,
12-13.
yes. That is also, Your Worship, because we approached the Honorable High Court, then only, as per the direction of this Honorable Court, they filled up 1/3 by way of promotion. Otherwise, they illegally suppressed the promotion quota and carried on filling up the vacancies by direct recruitment.
So you got the relief of being considered for promotion. Ultimately, two of you were considered and promoted.
Yes.
But now you're saying that since the promotion was initiated in 2012-13,
Yes.
your entry into the service should be from that date.
Seniority should be counted from
Seniority
that.
should be from that date.
As per 5F of this poem dated 4/3/2014. It was an arbitrary suppression of the promotion quota by the state respondents. Your Worship. In fact, if their colleagues had not approached this honorable court, they would have carried on direct recruitment without complying with the promotion quota.
Who approached the court? The petitioners? No.
Another colleague of the petition.
See Lalt Hazwala.
Yes,
And you got the benefit.
yes.
He also got the benefit.
He did not get the benefit. He did not get the benefit, I think.
He did not get.
Yeah.
He was in the consideration zone.
Yes. If he approached, if your Lordship will see,
The direction was such.
yeah, if he comes within the zone of consideration, his case shall be considered. Para 10. So, he was not selected.
He would not need agriculture.
So, the present petitioners sort of benefited from his actions by approaching the Honorable High Court.
No, what happened to this individual? He was considered but not selected.
He was not selected.
It is made clear that in the event the petitioner comes within the zone of consideration, his case for selection and promotion shall also be duly considered. So, the induction process is also a selection process,
Yes.
which involves
ACRs.
ACRs and anything else.
That is the 5-year service.
5-year service as Group A officer,
Group B.
Group B officer,
Yeah.
5-year service.
No, yes.
Is there any process of interview or something like that?
Nothing of that sort.
So whoever gets a better record in the service
Yes.
gets the priority.
Yes.
He initiated the writ petition, but the present two petitioners got the benefit.
Got the benefit.
But there were others also, isn't it?
Yes, Your Honor.
Because mention is made here that admittedly there were, how many? 9 vacancies, is it?
Yes.
Meant for induction.
Yes.
What has happened to the others? 7 of them.
But Your Lordship, although according to the judgment there were 9 vacancies, if Your Lordship will see at page 110, the process for induction was carried out for filling up only 4 vacancies. At page 110.
Process was carried on for?
Only 4 vacancies. Page 110. This is from the DPNAR to the MPSC. I am directed to inform you that in compliance with the Honorable Guwahati High Court judgment order dated 20th of August 2015, in WPC 44 of 2015, Government of Mizoram has decided to fill up 4 vacant posts of junior grade of MCS by induction. So the process was initiated for only 4 posts.
Ultimately, how many were selected?
3,
Where is that?
page 113.
This third person has not come?
Yes, he has not come.
Four vacancies initiated,
Sorry.
3
yes,
fill up.
Yes. Serial number 1 did not come. 2 and 3 have come.
2 and 3 are petition on 1 and 2.
Yes.
How do you say that you should be given the seniority? Even though you're not even born in the cadre at the relevant time.
Your Lordship, regarding that, I'd like to take your Lordship to the judgment of the Honorable Supreme Court in Harihara.
Yes.
Your Lordship, the first judgment was N.R. Parmar in 2012. In 2012, N.R. Parmar's case had held that although the appointment may be subsequent, but since the in N.R. Parmar's case, Your Lordship, the Honorable Supreme Court had held that for fixation of seniority between promotee and direct recruit, it is not the date of appointment, it is the date of initiation of process of recruitment. And accordingly, in N.R. Parmar's case, it was held that even though the direct recruitment process took a longer time and the direct recruits there were subsequently appointed, but the rota quota principle will apply, and the direct recruit should be interspaced with the promotee. In fact, in N.R. Parmar's case, it was the promotees who had challenged the seniority list, because the seniority list was fixed by the Government of India in accordance with the OM 7286 and 3786. And then the promotees had challenged the seniority list. Their case was that since they were promoted prior to the direct recruits and they were not even born on the cadre, they should be placed en bloc senior to the direct recruits. But in N.R. Parmar's case, the Honorable Supreme Court had held that the OMs will be applicable in case of rota quota rule, and the date of initiation of selection process is important. I think Joshua, it's better if I read from para 21 again, N.R. Parmar.
What has been stressed is the recruitment year,
Yes,
irrespective of which date you have joined
yes,
the post. Recruitment year is the
initiation of recruitment process.
initiation of recruitment process has to be reckoned
Yes.
for fixation of seniority.
But then in Megachandra's judgment, the Supreme Court had set aside this N.R. Parmar's judgment and had held that it will be the date of appointment which will be considered for fixing seniority. But that was in the case of Manipur Police Service rules, which clearly stated that the date of appointment will be taken into consideration for fixation of seniority,
As per the service rules.
as per the service rules. And Megachandra's judgment was given prospective effect from November 2019. So Parma's case was overruled prospectively, not retrospectively. Then Megha Chandra's judgment was again considered by another bench of two honorable judges of the Supreme Court. They held that Megha Chandra's judgment had not taken into consideration the decision of a coordinate bench in Subba Reddy and the decision of a constitution bench in Mervyn Coutinho's case. So they referred the matter to a larger bench. And this concept of, Your Worship, seniority between promotee and direct recruits not being based on the date of appointment, they have explained it out here in Hariharan's case. If I may take Your Lordship into judgment in Hariharan.
Subba Reddy came after Megh Chandra. Subba Reddy?
No, Subba Reddy's case was not considered in Megha Chandra's judgment.
Okay.
Even Mervyn Coutinho's judgment was not considered in Megha Chandra's judgment.
Subba Reddy's case is by what?
Three judges, almost three judges.
Three judges.
Coordinate bench. I'll take you to page para 32.
Mervyn Coutinho is by the Constitution Bench.
Constitution.
What is the law laid down by the Constitution Bench?
If I may read from para 32, Your Worship.
Of Hariharan?
Hariharan.
Yes.
Now we turn to the decision of the Constitution Bench in the case of Mervyn Coutinho. This court decided a petition under Article 32 of the Constitution of India, filed by the appraisers in the Customs Department. The Constitution Bench noted that the system which prevailed for recruitment to the post of appraisers was that 50% of posts were reserved for direct recruits and the remaining 50% were filled in by promotion from subordinate officers in the Customs Department. The contention raised in the petition was that this system has resulted in discriminatory treatment to the promotees, inasmuch as the promotees who had rendered much longer service in the cadre of appraisers were put in seniority below the direct recruits with much shorter service. There was one more grievance in the petition with which we are not concerned. The Apex Court referred to the circular OM dated 12 September 1959, which is referred in the OMs dated 7 February 86 and 3 July 86. After considering the submissions, the Constitution Bench held thus, para 6. Before we come to what has been done in 1963 in the matter of fixing seniority of appraisers, we may refer to two other circulars. The first is a circular of the board issued in 1953. That circular, in our opinion, has nothing to do with question of fixing of seniority as between direct recruits and promotees. Its main value is that it emphasizes that the proportion fixed for direct recruits and promotees should be rigidly maintained. It also directs that promotion to higher grades should be made on the basis of a combined seniority list of both direct recruits and promotees. Then there's another circular of 1955. That circular again emphasizes the rotational system and says that it has been decided that inter-se seniority of direct recruits and promotees in the grade of appraisers should be determined in the order in which the vacancy in that grade is filled by a direct recruit or by promotee according to the quota fixed for such appointments. Stress has been laid on behalf of the petitioners on the words "is filled" in this circular, and it is urged that this means that until the direct recruit is actually recruited and fills the vacancy meant for a direct recruit, he cannot get seniority from before the date he fills the vacancy merely on the ground of rotational system of fixing seniority. We do not think that this is the meaning of the words "is filled" used in this circular. We have already said that this circular also emphasizes the rotational system in the matter of fixing of seniority, and all that it means is that vacancies should be filled either by direct recruit or by promotees according to the quota fixed for such appointment. This brings us back to the circular of 1959, and the main question is that in that connection is the meaning to be assigned to the words seniority determined accordingly in the explanation to Principle 6 relating to relative seniority of direct recruits and promotees. As we read these words, their plain meaning is that seniority as between direct recruits and promotees should be determined in accordance with the roster, which has also been specified, namely one promotee followed by one direct recruit and so on. Where therefore recruitment to a cadre is from two sources, namely direct recruits and promotees, and rotational system is in force, seniority has to be fixed as provided in the explanation by alternately fixing a promotee and a direct recruit in the seniority list. We do not see any violation of the principle of equality of opportunity enshrined in Article 16.1 by following the rotational system of fixing seniority in a cadre, half of which consists of direct recruits and the other half of promotees. And the rotational system by itself, working in this way, cannot be said to deny equality of opportunity in government service. The anomalies which have been referred to in the petition arise not on account of there being anything opposed to equality of opportunity in government service by the use of rotational system. They arise out of the fortuitous circumstance that in this particular service of appraisers, for one reason or another, direct recruitment has fallen short of the quota fixed for it. It is merely because of this fortuitous circumstance that anomalies to which reference has been made in the petition have arisen. There is no doubt that if direct recruitment had kept pace with the quota fixed thereof, therefore, there would have been no anomalies in fixing the seniority list. The question therefore narrows down to this. Can it be said that there is denial of equality of opportunity which arises out of this fortuitous circumstance and which is not otherwise inherent in the rotational system? We are not prepared to say that the rotational system of fixing seniority itself offends equality of opportunity in government service. Any anomalies which may have resulted on account of insufficient recruitment of direct recruits in the past cannot, in our opinion, be a ground for striking down the rotational system, which, as we have said, does not itself amount to denial of equality of opportunity in the matter of employment in government service. It is regrettable that some anomalies have appeared because of insufficient recruitment of direct recruits in the past in this particular service. But that, in our opinion, can be no reason for striking down the seniority list prepared in 1963, which is undoubtedly in strict accordance with the rotational system based on the fixed quota for recruitment of direct recruits and promotees. The order of the board of 1963, on the basis of which impugned seniority list of appraisers has been prepared, clearly lays down that the principle of determination of seniority of the direct recruits and the promotees inter se in the prescribed ratio of 1:1 should be worked out. This order is in accordance with the circular of 1959, and as we have said already, there is no inherent vice in the principle of fixing seniority by rotation in a case where service is composed in fixed proportion of direct recruits and promotees. Para 33. The argument made before us is that, the argument made before us that, I'll come, that was, if I may take your lordship back to para 31, prior to para 32. If I may read para 31. It was held that although certain direct recruits were recruited subsequent to the promotees, their fitment in the order of seniority had to be determined with reference to rota and quota or rotation of quota prescribed under the rules. It was held that there was no illegality when the promotees were pushed downwards in the order of seniority. This court quoted with approval its earlier judgment in the case of Union of India versus S.D. Gupta. In this case, by applying the principle of rota and quota, the inter se seniority of the promotees and direct recruits was fixed. This court in the said case held that though direct recruits were recruited subsequent to appointment of promotees, the fitment of direct recruits and promotees must be determined with reference to the rota and quota prescribed. In paragraph 8, this court dealt with an argument that direct recruits were not born in the service when promotees were promoted, and therefore the promotee should not be pushed down. In para 8, this court held thus: it is then contended that direct recruits were not born in the service when promotees were promoted, and equity requires that they cannot be pushed down. The object of direct recruitment is to blend talent and experience to augment efficiency when direct recruits, though came from green pastures, were imbued with dedication and honesty. So long as system continues, consequences are inevitable. The question of equity does not arise. Sri Krishna Mani then contended that direct recruits are shown temporary and so they cannot be similar to promotees, substantive appointees. The quota of 60% of direct recruits is to substantive vacancies, though the initial appointment is temporary. On completion of period of probation, they become substantive appointees. That is the settled principle of law in this behalf. The tribunal, therefore, is not right in giving direction to consider the fitment vis-a-vis the order passed by this court in their quota above direct recruits. So, if this concept of seniority being considered from the date of appointment was also considered by the Honorable Supreme Court in the case of M. Subba Reddy. And in M. Subba Reddy's case, the Honorable Supreme Court had quoted with approval the judgment in the case of Union of India versus S.D. Gupta. So as long as the principle of rotation of quota is applicable, the question of date of appointment is not important. As long as the rota quota rule is applicable, then the seniority has to be fixed as per the rotation of vacancies and not based on the date of appointment. And even in our case, the MCS rules 2002 does not have any seniority rule. And even the state respondents in the affidavit have stated that the seniority has been fixed in accordance with the OM dated 4th of March 2014, which was issued as per the decision of the Honorable Supreme Court in N.R. Parma's case.
You just read out was the case of M. Subba Reddy.
Yes.
Correct.
Yes. That was a coordinate bench of
M. Subba Reddy.
Was not considered in the case of Megachandra.
No, in M. Subba Reddy,
M. Subba Reddy.
the case of S.D. Gupta was referred to.
Yes.
Correct.
With approval.
S.D. Gupta is a case of rendered by
Honorable Supreme Court.
two judges.
Yes.
M. Subba Reddy is a coordinate bench with the K. Megchandra's case.
Yes.
And in M. Subba Reddy's case, another case of S.D. Gupta was referred to.
Yes. With approval. And even the Constitution bench in the case of Mervyn Coutinho had held that the rotation of vacancies, rota quota,
Where is that particular paragraph?
which
Mervyn Coutinho.
it starts from para 32. Yeah.
No, what is the operative portion?
Yeah, para 6 and 7. In para 32, the Honorable Supreme Court has referred to the Constitution bench case of Mervyn Coutinho. And para 6 and 7 have been quoted.
It speaks about
Rotation of quota. Yes.
it is regrettable that some anomalies have appeared because of insufficient recruitment of direct recruits in the past
Yes.
in this particular service, but that, in our opinion, can be no reason for striking down the seniority list prepared in 1963. which is undoubtedly the in strict accordance with the rotational system based on the fixed quota for recruitment. So this 1963 list was challenged.
Yes.
Where does it find mention? I think we should get this judgment.
It's a very old judgment, 1966.
That will be available in AIR.
1966, 3 SCR, page 600.
Please get that.
1966, 3 SCR, page 600.
This matter was referred to a larger bench.
Yes.
This is an order dated 14 December 2022. Almost 2 years now. What has happened? Still pending.
It's still pending.
Under what name? Name of Hariharan.
Hariharan. If I may read from para 33, Ashwin. This is the finding of the Honorable Supreme Court in Hariharan. If I read from para 33 on.
Yes.
The argument made before is that the decision, the case of K. Megachandra will have to be ignored on the ground that it is per incurium, as the attention of the bench which decided the case was not invited to the binding decisions of the Constitution bench in the case of Mervyn Cotino and a coordinate bench in the case of M. Subba Reddy. Prima facie, we find substance in the argument that the attention of the bench which decided the case of K. Megachandra was not invited to the aforesaid binding precedents. Therefore, we are of the view that the appropriate course of action will be to refer the question to a larger bench. We are dealing with a case where rotation of quota or rota and quota system is being followed. If the promotees are recruited in the relevant recruitment year, but the process of recruitment of direct recruits, which commence in the same recruitment year, could not be completed in the same year, the direct recruits appointed subsequently will have to be interspaced between the promotees of the same recruitment year. In such a case, it cannot be said that direct recruits were not available during the recruitment year. Their appointment could not be made during the same year, though the process of appointment commenced in the same year. But if the process of recruitment of direct recruits is completed in the same recruitment year, but an adequate number of candidates could not be selected, the shortfall should be carried forward to the next recruitment year. In such cases, the candidates who are selected against shortfall vacancies will have to be bunched below the promotees of the earlier year.
That is not your case.
That is not our case. We were,
That there was shortfall.
yeah,
they
that
should
is not our
budge.
case. That is not our case. Para 34.
Yes.
Coming to the facts of the case, though process of recruitment of direct recruits to the post of income tax inspectors commenced in the recruitment year 2009-2010, the same could not be completed in the same recruitment year. This is not a case where adequate number of direct recruits could not be recruited, even though the recruitment was done in the recruitment year itself. In this case, those who were eligible for direct recruitment were deprived of the opportunity as the process of recruitment could not be completed during the same recruitment year 2009-2010 due to no fault on their part. The documents annexed to the counter affidavit show that the segregation of vacancies for 2009-2010 and 2010-11 have been properly made. In any event, the decision, the case of K. Megachandra, has a prospective operation. Seniority list of 7th September 2016 was made in terms of decision in the case of N.R. Parmar. Hence, the same could not be altered on 13 February 2018 when the said decision was in force. Thus, our conclusion can be summarized as under. The decision in the case of K. Megachandra requires reconsideration by a larger bench in view of the fact that the binding decision of the Constitution Bench in the case of Mervyn Coutinho and another binding decision of the Coordinate Bench in the case of M. Subba Reddy were not placed for consideration before the bench which decided the case of K. Megachandra. Even assuming that the case of K. Megachandra was correctly decided, paragraph 39 of the decision shows that the decision in the case of N.R. Parmar has been prospectively overruled by observing that the decision will not affect the interstate seniority already fixed on the basis of the case of N.R. Parmar, and the same was protected. It is also held that the decision will apply prospective except where seniority is to be fixed under relevant rules from the date of vacancy / the date of advertisement. In this case, as on the date when the case of N.R. Parmar was decided, there was no rule which required that the interstate seniority of direct recruits and promotees to the post of income tax inspectors should be fixed from the date on which a person is born in the cadre. In the facts of the case, the seniority list was correctly published on 7 September 2016 in terms of the decision in the case of N.R. Parmar, by interspacing those direct recruits who were eligible in the recruitment year 2009-2010 and were appointed against the vacancies of the said year with 53 promotees who were promoted by DPC dated 29 June 2009. Seniority list was later modified on 13 February 2018 without giving an opportunity of being heard to the affected direct recruits. So even in this case, the seniority list was fixed in 2016 after N.R. Parmar. Judgment came out in 2012. And subsequently, it was modified in 2018. So it was challenged by the direct recruits, saying that 2016 list based on N.R. Parmar should be upheld. So the decision, the High Court had upheld the case of the direct recruits, and held that the modified seniority list of 2018 has to be set aside, and the original seniority list of 2016, fixed in accordance with N.R. Parmar's case, will prevail. And the judgment of the High Court was challenged before the Supreme Court. So even in our case, the imputed seniority list, although claimed to have been based on N.R. Parmar's case by the state respondents, they have, according to us, wrongly interpreted the judgment of N.R. Parmar and the OM dated 4/3/2014 based on N.R. Parmar. Because 5E and F of the OM dated 4/3/2014 are very important. They say that the date of requisition will be complete only when the ACRs were transferred to the MPSC. So that is why the seniority can be counted only from the date of appointment in 2015, January. But that is according to us, that is a wrong interpretation of the OM dated 4/3/2014, as well as N.R. Parmar's case, which clearly states that the date of requisition.
So in our Parmar's case, speaks about interspacing.
Yes.
I
Rotation
think
of
the
quota.
rotation of quota, and those on the same recruitment year or recruitment time should be interspaced as per the rota quota. That has been overruled by Megh Chandra's case,
Yes.
but prospectively.
Yes. Perspective.
And one more thing in Megh Chandra's case is that the service rule provided
Provides
that from the date of
on
appointment,
the
your
date of
seniority will be
appointment.
counted.
Yes.
So now, when the matter came up before this Hariharan, then what was noticed was that M. Subba Reddy's case also speaks about
Rotation of
rotation, coordinate bench.
Yes.
Then Mervyn Kotindo's case also, constitutional bench also approves of this rotation.
Quota.
These things were not considered.
Yes.
So it has to be reconsidered by a larger bench.
Yes.
It's gone back. Matter remains there as of date.
But in the meantime, Your Worship, since the judgment in that Hariharan's case, since the seniority list was of 2016 and modified in 2018, Supreme Court held that it is covered by N.R. Parmar's case. So, N.R. Parmar's judgment has to be complied with.
In your case, seniority is of
June 2000.
April.
June 2018.
Of course, 21st June 2018.
And yes, there were, Your Worship, initially there was one seniority list which was issued on 4th of September 2015. But after that, there were two more provisional, and the final seniority was again issued on 21st of June 2018. So we have challenged both. And I made a wrong statement, Your Worship, in 95 of 2019, the second writ petition, Your Worship, the petitioner in WPC 44 of 2015, C. Lal Thazwala, he was recommended, but he declined to join. That is why only 3 people were appointed.
Okay. He was also recommended.
He was recommended, but he declined the offer.
Do you have that recommendation?
I don't have the recommendation, Your Worship,
But how do you say then?
but that is as per information of my clients.
Okay.
Page 103, C. Lal Thazwala, he was the petitioner. And at page 113 is the appointment order.
113.
Yes.
Whose appointment?
The petitioners in WPC 95 of 2019.
It is available at page 35 also. Why have we annexed it in 2 places?
Yes.
My lord, I am representing all the private respondents except respondents 13 and 14 and 43, my lord. 13, 14 and 43.
13?
14 and 43
In which case?
in the
The first
WPC
case.
127, first case, my lord.
Okay.
Lord, my first submission will be, Your Lordship, whereas the petitioners are saying that on the basis of the OM 4/3/2014, their seniority should be reckoned from the date of initiation of the recruitment process, that is 9/8/2010. And also when the DPR are invited and requested the MPSC to initiate the process for filling up of 15 vacant posts, my lord. They are saying that it should be counted from 9/8/2010 instead of their actual promotion induction, that is 15/1/2015. However, Lordship, this is not what the said OM said. Because on perusal of the OM dated 4/3/2014, particularly paragraph 5E, my lord, I may take a Lordship to page 117. This is the OM. Because the interpretation correctly made by the state is, there is no wrong in this regard, my lord. Read petition I am referring, my lord, page 117. This is the OM. And I'll just come directly to page 118. Para 5 is the relevant para.
Yes.
And I'll start reading from para 5, subclause B. B, C, D, E, F. I'll read, my lord.
Yes.
B. The rotation of quota based on the available direct recruits and the promotees appointed against the vacancies of a recruitment year as provided in the OPTOM dated 7/2/1986 and 3/7/1986 would continue to operate for determination of inter-se seniority between direct recruits and promotees. The available direct recruits and promotees for assignment of inter-se seniority would refer to the direct recruits and promotees who are appointed against the vacancies of the recruitment year. The recruitment year would be the year of initiating the recruitment process against a vacancy year. And E, my lord, E is
Just
what
a
I would
minute.
like to, yes.
You call the Jamadar, not the PS.
May I continue, my lord?
Yes.
My lord, E is what I'm going to emphasize. Initiation of recruitment process against a vacancy year would be the date of sending of requisition for filling up of vacancies to the recruiting agency in the case of direct recruits. In the case of promotees, the date on which a proposal, complete in all respects, is sent to the UPSC chairman DPC for convening of DPC to fill up the vacancies through promotion would be the relevant date. I'll pause here, my lord. What it says here is that for direct recruits, for direct recruitment, it is the initiation of recruitment,
Garam pani lo.
initiation of recruitment process against the vacancy year. It should be from the date of sending of the requisition for filling up of the vacancies. And in respect of the promotion, my lord, induction, it is the date on which a proposal, complete in all respects, is sent to the MPSC in the present case. So, my lord, in respect of the present matter, after 15 posts, that is 10 direct and 5 for promotion, became vacant, my lord, it was initiated by sending a letter, requisition letter on 9/8/2010, and that was followed by notification 19/11/2010 inviting interested eligible officers. And then the process of filling up of 5 promotional posts was, my lord, cancelled thereafter. And then in pursuance of the judgment order passed in 23/7/2014 WPC 127 of 2013. The process was initiated again. And then one important point is that ACRs of the petitioners were submitted to the MPSC on 17/10/2014, my lord. On 17/10/2014. That is as also stated by the state's affidavit in opposition, para number 4. The ACRs of the petitioners, my lord. And thereby culminating into their petitioners' induction in the junior grade of MCS on 15/1/2015. There was sending of their ACRs was followed by their induction in the junior grade of MCS on 15/1/2015.
Yes.
So, my lord, by coming back to para 5E of the OM 2014, it is considered correctly, my lord, their seniority. For I'm talking about the promotion.
Paragraph E.
E.
5E.
5E, my lord.
Please read again.
Okay. Initiation of recruitment process against a vacancy year would be the date of sending of requisition for filling up of vacancies to the recruiting agency in the case of direct recruits. In the case of promotees, the date on which a proposal, complete in all respects, is sent to UPSC or Chairman DPC for convening of DPC to fill up the vacancies through promotion would be the relevant date. So what I am submitting is that, my lord, it was on the date that is 17/10/2014 when the proposal was complete in all respect, because that is the date of sending the ACRs to the MPSC for the petitioners, my lord, and which was culminating into their final promotion induction on 15/1/2015. So what I'm saying is that there is no wrong, my lord.
What about clause F?
Clause F, my lord, yes. Clause F says that initiation of recruitment process for any of the modes, that is direct recruitment of promotion, would be deemed to be the initiation of recruitment process for the other modes as well, my lord. In this regard, by reading NR Parmar's case, NR Parmar's case didn't specifically mention about this clause F. It specifically mentioned about clause E. So, my lord, clause F means is that from our interpretation is that, my lord, it mentions about this is for the purpose of rotation of quotas between direct recruits and promotees, whose recruitment falls on different dates but within the same year only, my lord. Not the recruitment process which was initiated in a completely different years. Because, my lord, by reading to, I'll just come to clause, first of all, my lord, clause F, then I'll just read again the preceding clauses with your lordship permission, my lord. Clause F says, initiation of recruitment process for any of the modes, direct recruitment or promotion, would be deemed to be the initiation of recruitment process for the other mode as well. Then para 5D, clause D says, my lord, recruitment year would be the year of initiating the recruitment process against a vacancy year. Here, clause F says initiation of recruitment process. And initiation of recruitment process for any of the modes so and so. And clause D says the recruitment year would be the year of initiating the recruitment process. And initiation of recruitment process is mentioned, it clarified, explained here under clause E. So what I have just read, my lord, for the direct recruitment, it is the date of sending the requisition, and in the case of promotees, it is the date of the proposal, which was complete in all respects, is by sending it to the UPSC or Chairman DPC. So we have to have the conjoint reading, my lord. Clause DEF. So what it means is that it is for the purpose of the rotation of the quotas between direct recruits and promotees, whose recruitments were on different dates but within the same year, my lord. NR Parmar's case also did not say in line with what the petitioners are claiming, my lord. So, Your Lordship, it is correct to say that for the private respondents who are direct recruits, initiation of recruitment process against vacancy year is 9/8/2010 because clause E of paragraph 5 of the 2014 OM says, which is the requisition of sending the requisition to the MPSC for direct recruitment. However, that paragraph 5 clause E itself says that for the promotion, in respect of promotion, it is in the present case 17/10/2014 when the ACRs were sent to the MPSC. So this is regarding my first point is that, my lord, regarding the OM 2014, the state's interpretation, state government's interpretation is not wrong regarding the relative seniority between direct recruits and promotees. And Your Lordship, my second point is that,
When was the
yes,
advertisement for direct recruitment?
advertisement, my lord, direct recruitment.
38 is the information given to the MPSC
Yes,
for conduct of competitive examination
yes, my lord, it was sent on.
for direct and also for willingness
It
to
was-
those who want to be inducted.
It was initiated with letter 9/8/2010, that is page 38, my lord.
This was common for both
Yes,
direct as well as induction.
yes, my lord.
Then page 40 is regarding induction.
Yes,
Where is the relevant notification for direct recruitment?
direct recruitment. My
There
lord,
must have been a
page-
separate notification, isn't it?
Yes. I think it is not an X, but page 43 is the, my lord, this is the withdrawal of 5 posts promotion by way of promotion, and it is modified, my lord. Second para says that the earlier letter dated 9/8/2010 was modified by exclusion of 5 posts, that is promotion. Then the 10 posts, filling up of 10 posts direct recruitment should be proceeded.
So 10th May, information was given that you can go ahead with the
Yes,
filling up of 10 posts by direct recruitment.
correct, my lord.
So when did they start advertisement?
Advertisement is not annexed in the writ petition, my lord.
That is why I'm asking you.
Yes,
You are for the respondents, so you must be knowing. Petitioners claim otherwise is that both process started
my lord.
together. As per the communication dated 9th August 2010.
My lord. If necessary, I'll try to obtain the copy also, your lordship.
So what you have basically submitted so far is that it's regarding the interpretation with OM. But is the OM in terms of the farmer's judgment?
NR Parmar's judgment, my lord, that is my second point. By particularly reading this NR Parmar's judgment, paragraph 31.2, and 34.1, 34.2, my lord. We'll be able to see that this considers about the direct recruits, not the promotee. So it had correctly held that in NR Parmar's case, that it has to be reckoned from the date of initiation of the process. Yes, it is correct by saying that in respect of the direct recruit, but for promotees, it is from the date when the proposal was made, in complete in all respects, my lord.
Complete in all respects has been added in that memorandum.
Yes.
Is it there in our Parmar's case?
NR Parmar's case, it mentions only about the direct recruits. That is why. Then the petitioner's interpretation is in such a way that
What about complete in all respect in respect of direct recruitment also?
direct recruits is
Advertisement, forms are sent, examinations conducted, interviews held, all those things.
my lord, for direct recruit, it doesn't say, OM doesn't say that complete in all respects. It is from the date
It does
of
not say, but will it
Yes.
not be same? Will it not be similar in direct recruitment also?
No, my lord, because clause E.
Simply giving advertisement is not complete in all respect. You have to go and participate. You have to give your papers, your testimonials, which will be scrutinized, accepted. The date of accepting your testimonials should be the date wherein it is complete in all respect.
I understand, my lord. However,
Can it be like that
no, my lord,
as well?
that clause, no.
If
your lordship.
if you're inviting a test saying that unless we receive the ACR
Yes.
copy, we cannot say it's complete.
Yes.
The moment we receive ACR for scrutiny, then we can say, okay, now we have the materials in our hand. It's complete.
Yes.
Similarly, for direct recruits, simply giving your application form, filling up application form, can it be considered to be complete in all respect?
However, lordship, by reading clause E,
There are certain processes
Yes.
also, even for direct recruitment. No, I'm just giving a
Yes.
hypothetical view.
yes, yes, my
If
lord.
that is the reasoning given, why not the reasoning for the direct recruitments as well?
Hmm.
Now, of course, NR Parmar's case is just the opposite in the sense that,
Yes.
but the principle is the same. It's just the opposite. It was a case wherein direct recruits were not given preference because they were appointed in later
Yes.
in time because of a lengthy process.
Yes.
Departmentally, they may promote within 2 sittings they promote, but direct recruitment through open, advertisement and all that, it takes long time.
Yes.
So, which paragraph you wanted
Paragraph
to
31
stress?
31.2 first, my lord.
Yes, read.
It is not necessary that the direct recruits for vacancies of a particular recruitment year should join within the recruitment year during which the vacancies had arisen itself. As such, the date of joining would not be a relevant factor for determining the seniority of direct recruits. It would suffice if action has been initiated for direct recruit vacancies within the recruitment year in which the vacancies had become available. This is so because delay in administrative action, it was felt, could not deprive an individual in his due seniority. As such, initiation of action for recruitment within the recruitment year would be sufficient to assign seniority to the appointees concerned in terms of the rotation of quotas principle, so as to arrange them with other appointees from the alternative source for vacancies of the same recruitment year. So this is what what it says is that, my lord, regarding direct recruitment. And the relevant paragraph I would like to stress also is page para 34.1.
But how does it help you?
What I'm trying to say is that, my lord, it is the date of joining would not be a relevant factor.
Not
for the-
relevant. Date of
Yes.
joining is not relevant. You
Not
joined
relevant.
earlier. They joined
Yes.
later on.
Yes,
But it is the recruitment year.
recruitment year.
They say the recruitment year is 2010.
Yes.
Why have you given us 2015? What is your answer to that? paragraph 32 or 31.2, how does it help you?
Yes, what I'm trying to say is that, my lord, it speaks about direct recruit, not the promotees. And it is on the in pursuance of this NR Permer's case that OM 2014 was also
See,
issued.
Don't rely upon that direct recruit promotees thing.
My lord.
We are talking about the principle.
Yes,
It may be the direct recruits in this case who have been belatedly appointed
yes,
and the promotees earlier appointed.
yes.
It can be the other way around also. But even whatever it may be, if it's the same recruitment year,
I understand.
just because you join first,
Yes,
you
yes.
cannot say that you will be senior to me.
Yes,
If the rule provides for rota quota, so it has to be interspace between the same promotee direct like that. This is what has been explained here.
however, lordship, after this NR Permer's judgment, OM 2014 was issued. And by referring to conjoined reading with this OM 2014, particularly para 5 and NR Permer's case, now the petitioners are relying upon NR Permer's case as well as OM, because OM is has to be given more priority, your lordship. Because now we are based, the present case, if the petitioner is saying that is to be correctly interpreted by way of OM 2014, then what I'm saying is that OM 2014-5, on perusal of the para 5 clause E, it is apparently clear, my lord. Then in our Permer's case, by reading of it, as your lordship had stated, your lordship, I understand. But we have to have the conjoined reading with OM 2014. Because petitioners are trying to say that this clause E and F, along with NR Permer's case, they are also entitled to claim seniority from 9/8/2010. However, my lord, this NR Permer's case, it is the opposite to their stand, because it's regarding direct recruitment. That is what I'm saying. I don't know whether I'm explaining myself clear or not. And para, okay, my lord, if para 34.2 is also relevant.
This OM has been challenged or not, Mr. Malhotra?
No, Your Lordship.
You have not challenged.
We have not challenged it. Now, this OM is based on NR Parmar's case.
Okay. We'll come back at 2.
My lord.
Yes, Mr. Bill.
My lord, I'll just come again to NR Parmar's decision, my lord, judgment. 34.1, para 34.1. I may read para 34.1 and 34.2.
Yes.
If the process of recruitment has been initiated during the recruitment year in which the vacancies have arisen itself, even if the examination for the said recruitment is held in a subsequent year and the result is declared in a year later than the one in which the examination was held, and the selected candidates joined in a further later year than the one in which the result was declared, the selected candidates will be entitled to be assigned seniority with reference to the recruitment year in which the requisition of vacancies were made. The logic and reasoning for the aforesaid conclusion expressed in the office note dated 2/2000 is, if the process of direct recruitment is initiated in the recruitment year itself, the selected candidates cannot be blamed for administrative delay in completing the process of selection. The words initiation of action for recruitment and the words initiation of recruitment process were explained to mean the date of sending the requisition to the recruiting authority. So, my lord, what I'm saying is that even on the basis of the NR Parmar's case, what it says is in respect of direct recruitment only, not the promotion. However, if the petitioner is saying that this NR Parmar's, what it says, initiation of recruitment process, the date of requisition of to the recruiting authority could also be applicable even to the promotees. However, my lord, after this judgment, OM 2014 was issued, and conjoined reading with this OM dated 4/3/2014 and NR Parmar's case, then it is very clear, particularly para 5 clause E, then it has to be segregated, my lord. Initiation of recruitment requisition, the date of requisition sent to the recruiting authority, as per clause E, it is only for the direct recruitment, my lord, not for the promotion. It appears that the reason why it has been observed by NR Parmar's case is that the recruitment process for direct recruitment is lengthy comparing to the promotional process, my lord. So this is my contention. So what I'm saying is that even on the basis of this OM 4/3/2014 as well as NR Parmar's case, the relative seniority as considered by the state respondents is correct, and there is no illegality or wrong in this regard, my lord. Therefore, my lord, the seniority list which they are challenging, that is dated 4/9/2015 and 21/6/2018, should not be reopened at this stage. So the reason why I'm saying is that it should not be reopened is that there is no wrong or illegality in this regard. And my next point is, my lord, even on assuming that seniority list should be reopened and reconsidered, and it has to be done by applying K. Megachandra's case, because this is the law which is existing law applicable at this stage. If the petitioners are trying to reopen and they are saying that it has to be reconsidered, at this stage the applicable law is K. Megachandra's case. Lord, I'll refer to Megachandra's case, that is 2020 volume 5 SCC 689. First, I'll come to para 39 regarding how it has to be applied. It says that it had the decision will apply prospectively. Para 39, my lord.
Yes.
Your lordship, I'll counting from fifth, from the bottom of this para 39, I'll start from fifth line. It starts with accordingly. Has your lordship got it, my lord?
Starts with accordingly.
Yes, I'm counting from the bottom, para 39. Fifth line. Just above this
Yes, accordingly.
alphabetical F, yes. Accordingly, the decision in NR Permer is overruled. However, it is made clear that this decision will not affect the inter se seniority already based on NR Permer, and the same is protected. This decision will apply prospectively except where seniority is to be fixed under the relevant rules from the date of vacancy or the date of advertisement. So, my lord, this, although, what I'm saying is that, although this particular judgment, K. Magachandra's case, judgment says that decision will apply prospectively except where seniority is to be fixed under relevant rules from the date of vacancy or date of advertisement. From this, it transpires that what had already been settled on the basis of NR Permer's case should not be reopened. So that is why it says that, my lord, it has to be applied prospectively. But even at this stage, if the petitioners are saying that the seniority list which has already been considered correctly needs to be reopened and reconsidered at this stage. But there is no bar that K. Megachandra's case, which is the applicable law at this stage, should be applicable, my lord. There is no bar. So this is my contention. Because while saying this, I would like to rely upon one judgment, that is 2008 volume 14. Uh, 2014, 2008 volume 14 SCC 171, para 35. It says that there is a well settled judicial decision acts retrospectively, my lord. My lord, I'll read. In our judgment, it is also well settled that a judicial decision acts retrospectively. According to Blackstonian theory, it is not the function of the court to pronounce a new rule, but to maintain and expound the old one. In other words, judges do not make law, they only discover or find the correct law. The law has always been the same. If a subsequent decision alters the earlier one, the later decision does not make the new law, it only discovers the correct principle of law, which has to be applied retrospectively. To put it differently, even where an earlier decision of the court operated for quite some time, the decision rendered later on would have retrospective effect, clarifying the legal position which was earlier not correctly understood. Why I am referring this is that, my lord, the learned counsel for the petitioner's contention is that the seniority list were not considered correctly, and it has to be, if it has to be reconsidered on the basis of NR Permer's case only, not K. Megachandra's case, because it is applied, it has to be applied prospectively, not retrospectively. That is what he said. However, lordship, by reading para 39, what had already been settled of Megachandra's case, I am saying, my lord, what had already been settled should not be reopened in view of this K. Megachandra's case, which has to be applied prospectively. The reason why it says prospectively it has to be applied is that it was already settled, those which had already been settled as per NR Permer's case. But if at this stage it is going to reopen or reconsider, then the law will be, which will be applicable, is K. Megachandra's case. That is what I am saying, my lord. So then I'll just come to K. Megachandra's case, how correctly the observation had been made and why NR Permer's case had been overruled. My lord, I'll refer again to K. Megachandra's case. 2020, Volume 5, SCC 689. I'll come directly to relevant paragraphs. Para 28, 29, 30, 37, 38, and 39. I may read these paragraphs, my lord, so it will, and what is not relevant, I'll skip.
Which paragraph? you
Paragraph
want to
28 of K. Meghachandra's case.
read? Yes, read.
Before proceeding to deal with the contention of the appellant's counsel vis-a-vis the judgment in NR Parmar, it is necessary to observe that the law is fairly well settled in a series of cases that a person is thus entitled to claim seniority from a date he was not born in service. For example, in Jagdish C.H. Patnaik, the court considered the question whether the year in which the vacancy accrues can have any bearing for the purpose of determining the seniority, irrespective of the fact that the person is actually recruited. The court observed that there could be time lag between the year when the vacancy accrues and the year when the final recruitment is made. Referring to the word recruited occurring in the Orissa Service of Engineers Rules 1941, the Supreme Court held in Jagdish C.H. Patnaik that person cannot be said to have been recruited to the service only on the basis of initiation of process of recruitment, but he is born in the post only when formal appointment order is issued. Para 29. The above ratio in Jagdish C.H. Patnaik is followed by this court in several subsequent cases. It would, however, be appropriate to make specific preference considering the seniority dispute in reference to the Arunachal Pradesh rules, which are in pari materia to the MPS Rules 1965, White Nani Shah versus State of Arunachal Pradesh. Having regard to the similar provisions, the court approved the view that seniority is to be reckoned not from the date when vacancy arose, but from the date on which the appointment is made to the post. The court particularly held that retrospective seniority should not be granted from a day when an employee is not even born in the cadre, so as to adversely impact those who were validly appointed in the meantime. Para 30. We may also benefit by referring to the judgment in State of UP versus Ashok Kumar Srivastava. This judgment is significant since this rendered after NR Parmar's decision. Hence, the court approved the ratio in Pawan Pratap Singh versus Rivan Singh and concurred with the view that seniority should not be reckoned retrospectively unless it is so expressly provided by the relevant recruitment rules. The Supreme Court held that seniority cannot be given to an employee who is yet to be born in the cadre, and by doing so, it may adversely affect the employees who have been appointed validly in the meantime. I'll stop here, my lord, regarding para 30. I'll come to para 37. When we carefully read the judgment in NR Parmar, it appears to us that the referred OMs dated 7/2/1986 and 3/7/1986 were not properly construed in the judgment. Contrary to the eventual finding, the said two OMs had made it clear that seniority of the direct recruits be declared only from the date of appointment and not from the date of initiation of recruitment process. But surprisingly, the judgment, while referring to the illustration given in the OM, in fact overlooks the effect of the said illustration. According to us, the illustration extracted in NR Parmar itself makes it clear that the vacancies which were intended for direct recruitment in a particular year 1986, which were filled in the year 1987, could be taken into consideration only in subsequent years' seniority list, but not in the seniority list of 1986. In fact, this was indicated in the two OMs dated so and so, and that is why the government issued the subsequent OM 33/2008, or by way of clarification of the two earlier OMs. Para 39, my lord. Sorry, para 38, and then I'll come to 39. At this stage, we must also emphasize that the court in NR Parmar need not have observed that the selected candidate cannot be blamed for administrative delay and the gap between initiation of process and appointment. Such observation is fallacious inasmuch as none can be identified as being a selected candidate on the date when the process of recruitment had commenced. On that day, a body of persons aspiring to be appointed to the vacancy intended for direct recruit was not in existence. The persons who might respond to an advertisement cannot have any service-related rights, not to talk of right to have their seniority counted from the date of the advertisement. In other words, only on completion of the process, the applicant morphs into a selected candidate, and therefore unnecessary observation was made in NR Perma to the effect that the selected candidate cannot be blamed for the administrative delay. In the same context, we may usefully refer to the ratio in Sankarsan Das versus Union of India, where it was held that even upon empanelment, an appropriate does not acquire any right. The judgment in NR Perma relating to the central government employees cannot, in our opinion, automatically apply to the Manipur state police officers governed by the MPS Rules 1965. We also feel that NR Perma had incorrectly distinguished the long-standing seniority determination principles propounded in inter alia Jagdish C.H. Patnaik, Suraj Prakash Gupta versus State of J&K, and Pawan Pratap Singh versus Rivan Singh. These three judgments and several others with like enunciation on the law for determination of seniority makes it abundantly clear that under service jurisprudence, seniority cannot be claimed from a date when the incumbent is yet to be born in the cadre. In our considered opinion, the law on the issue is correctly declared in Jagdish C.H. Patnaik, and consequently we disapprove the norms on assessment of inter-se seniority suggested in NR Perma. Accordingly, the decision in NR Perma is overruled. However, it is made clear that the decision will not affect the inter-se seniority already based on NR Perma, and the same is protected. This decision will apply prospectively except where seniority is to be fixed under relevant rules from the date of vacancy or date of advertisement. So, my lord, it is very clear from K. Megachandra's case that an incumbent, a person who is not yet born in the cadre or service, he cannot claim seniority from that date when he was not even born yet, my lord. And in similar lines, my lord, I would like to rely upon another judgment, that is 2021 SCC online, SC 281. SCC online, my lord. Para 10, 11, 12 and 16. Paragraph 10, 11, 12 and 16. I'll read from 10, my lord. As earlier noted, the respondent entered service only on 10/2/1996, and yet under the impugned judgment, the High Court directed counting of his seniority from 2011-1985, when he was not born in service. The jurisprudence in the field of service law would advise us that retrospective seniority cannot be claimed from a date when an employee is not even born in service. It is also necessary to bear in mind that retrospective seniority, unless directed by court or expressly provided by the applicable rules, should not be allowed, as in so doing, others who had earlier entered service will be impacted, my lord. My lord, I think it may not be necessary to read the whole paragraphs, but I will rely upon para 10, 11, 12 and 16. Another one is 2007 volume 1 SCC 683. Para 28 to 31, my lord.
Yes.
I'll read this para 28 first, Your Lordship.
Yes.
It is clear from the above that a person appointed on promotion shall not get seniority of any earlier year, but shall get the seniority of the year in which his or her appointment is made. Therefore, in the present fact situation, the respondent cannot claim promotion from the date of occurrence of the vacancy, which is 1995 to 96, but can only get promotion and seniority from the time he has been substantively appointed, that is from 1999. Likewise, the seniority will also be counted against the promotion and appointment in the cadre from the date of issuance of order of substantive appointment in the said cadre, that is from 1911-1999. In a recent judgment of this court in Uttaranchal Forest Rangers Association, direct recruit versus state of UP, so and so, this court was of the view that seniority has to be decided on the basis of rules in force on the date of appointment. No retrospective promotion or seniority can be granted from a date when an employee has not even been born in the cadre. Similar view was taken in this court in case of Chandra Joshi versus Union of India. I'll skip para 30. I'll come to para 31, my lord. This court in Vinod Danan Yadav versus State of Bihar held on an issue regarding the interstate seniority among the direct recruits and promotees. The court applying the ratio of State of Bihar versus Akhori Sachindra Nath held that the appellants who are direct recruits shall be considered senior over the promotees not born on the cadre when the direct recruits were appointed in service. Hence, the gradation list drawn under which promotees were given seniority over the direct recruits could not be sustained and was thereby set aside. My lord, if the petitioners are allowed to count their seniority with effect from 9/8/2010, and that would be the time when they were still serving in their respective department as gazetted officers, and they did not yet born in the cadre in the junior grade of MCS. And as per the citations which I had read out, as well as K. Chandra's case, this should not be admissible in law, my lord. And although I have highlighted in a short submission, my lord, regarding clause F of para 5, I would like to reiterate that, my lord, it has to be with conjoined reading with other clauses, clause C, D, E, and F. Because the petitioners are stressing upon this clause F, which says that initiation of recruitment process for any of the modes, that is direct recruitment or promotion, would be deemed to be the initiation of recruitment process for the other mode as well. But as I have submitted, Your Lordship, if we have the conjoined reading with this initiation of recruitment process meaning as mentioned in clause E, for promotion, Your Lordship, for the promotees, it is on the date on which proposal complete in all respects was sent to the DPC, in the present case MPC, my lord, MPSC, sorry. Your Lordship, regarding Hariharan case, N.R. Parmal's case was overruled by Megachandra's case. Thereafter, Hariharan case, Megachandra's case, 3 judges bench decision, and thereafter Hariharan's case, my lord, 2 judges bench decision, and it was referred to the larger bench as the learned counsel for the petitioner had mentioned about it. And it is, although it is not yet decided, my lord, till today, but the law as laid down in Union Territory of Ladakh versus Jammu and Kashmir National Conference, it says that, my lord, if there are 2 conflicting judgments between the courts of equal strength, and if that is referred to the larger bench, it is the earlier one which is to be followed by the courts. I'll rely upon this, my lord. 2023 SCC online SC 1140. I'll come directly to para 35, my lord. I'll read para 35. We are seeing before us judgments and orders by high courts not deciding cases on the ground that the leading judgment of this court on this subject is either referred to a larger bench or a review petition relating thereto is pending. We have also come across examples of high courts refusing deference to the judgments of this court on the score that a later coordinate bench has doubted its correctness. In this regard, we lay down the position in law. We make it absolutely clear that high courts will proceed to decide matters on the basis of the law as it stands. It is not open, unless specifically directed by this court, to await an outcome of a reference or a review petition, as the case may be. It is also not open to a high court to refuse to follow judgments by stating that it has been doubted by a later coordinate bench. In any case, when faced with conflicting judgments by benches of equal strength of this court, it is the earlier one which is to be followed by the high courts, as held by a 5-judge bench in National Insurance Company Limited versus Pranay Sethi, 2017, Volume 6 SCC 680. The high courts, of course, will not do so with careful regard to the facts, and circumstances of the case before it. So, only due to the fact that Hariharan's case referred the matter to the larger bench, it cannot be said that my lord K. Magichandra's case should not be applied. And your lordship, my next submission is regarding the belated claim made by the petitioners. If the petitioners are first aggrieved with final inter-se seniority list 4/9/2015, and due to that reason they are challenging this 2015 seniority list along with the subsequent notification final inter-se seniority list published on 21/6/2018. However, your lordship, if they are first aggrieved with the inter-se seniority list dated 4/9/2015, then they should have challenged it within a reasonable time. But they filed the present writ petition after 4 years in the year 2019 in the month of September, my lord. And now, so before coming to the citation in which I will be relying upon, I would like to bring to this honorable court's notice that at the time of filing of the writ petition, the private respondents were already promoted to the senior grade, and that was also reflected in the writ petition. Now, they had already further been promoted to the JAG grade, my lord. And these are, I would like to place before your lordship, because these are not included in the pleadings. I'm trying to say that this had become settled position regarding the seniority.
How do you say it's delay?
Delay, my lord,
Counting from which date?
counting from the date of the final seniority list dated 4/9/2015.
4/9/2015.
4/9/2015. They are challenging two seniority lists in the present writ petition.
Okay.
The first one is 4/9/2015, and the subsequent one is 21/6/2018.
Both are final seniority.
Both are
lists.
final. The first one is, my lord, respondent 4 to 12. They are saying that they have to be interspaced with respondents 4 to 12, who were earlier appointed on the basis of the requisition dated 9/8/2010. And respondents 42 to 50, they are interspaced with this respondents 40 to 50, 42 to 50, and they are aggrieved with that. And the subsequent interstate seniority was also challenged in the which was published in the year 2018. But if they are aggrieved with the first seniority list, that is on 4/9/2015, then right away they should have challenged, my lord. But belatedly in the year 2019 only they had filed this writ petition. And I'll come to the relevant judgments of the Honorable Apex Court in this regard, my lord, which says that, first, my lord, yes, I'll produce these judgments. It says that in service matters, the question of settled position of seniority should not be reopened or unsettled after a lapse of reasonable period of time. There is 2010, volume 12 SCC. 2010, volume 12 SCC 471. Para 19 to 30, my lord. (19 to 30).
19 to
To 30, 30.
altogether 11 paragraphs.
Yes, but these are short ones only, my lord.
Just a minute, Miss Mary. You would like to leave? Go ahead. We'll take up this matter again. I'll hear you tomorrow. Yes. Paragraph 19.
19, my lord. This court in Ramchandra Shankar Deodhar case also placed reliance upon its earlier judgment of the constitutional bench in Rabindranath Bose versus Union of India, wherein has been observed as under Rabindranath Bose case so and so, it would be unjust to deprive the respondents of the rights which have accrued to them. Each person ought to be entitled to sit back and consider that his appointment and promotion effected a long time ago would not be set aside after a lapse of number of years. In R.S. Makasi versus I.M. Menon, this court considered all aspects of limitation, delay and laches in filing the writ petition in respect of interstate seniority of employees. The court referred to its earlier judgment in State of MP versus Bailal Bai, wherein it has been observed that maximum period fixed by the legislator as time within which the relief by a suit is civil court must be brought may ordinarily be taken to be a reasonable standard by which delay in seeking the remedy under Article 226 of the Constitution can be measured. And I'll skip the remaining. I'll come to Para 21. The issue of challenging the seniority list, which continued to be in existence for a long time, was again considered by this court in K.R. Mugdal versus R.P. Singh. The court held as under, a government servant who is appointed to any post ordinarily should, at least after a period of 3 or 4 years of his appointment, be allowed to attend to the duties attached to his post peacefully and without any sense of insecurity. And I'll come to Para 22, my lord. Or your lordship, I think it will be enough to have the understanding about what I'm trying to say and what this judgment says. And I'll skip reading the remaining paragraphs, but I'll be relying upon Para 19 to 30, 30. Just to save the time, may not be necessary to read the remaining ones. And or my lord, Para 30 may be relevant. I'll just read this. Para 30. Thus, in view of the above, the settled legal proposition that emerges is that once the seniority has been fixed and it remains in existence for a reasonable period, any challenge to the same should not be entertained. In K.R. Mudgal, this court has laid down in crystal clear words that a seniority list which remains in existence for 3 to 4 years unchallenged should not be disturbed. Thus, 3 to 4 years is a reasonable period for challenging the reasonable, and in case someone agitates the issue of seniority beyond this period, he has to explain the delay and laches in approaching the adjudicatory forum by furnishing satisfactory explanation.
So seniority was of 2015,
Yes,
writ petition filed in 2019,
19.
4 years.
4 years. But no explanation is given, and my lord, it was reasonable. However, in the preceding paragraphs, it says that the reasonable period has to be considered, my lord. And several judgments had been quoted in which the citation which I'm relying upon. And 2012 volume 7 SCC, my lord. My last citation.
This is on delay again.
Yes.
2012.
12 volume 7 SCC 610. Para 23 to 27. I'll read para 23, my lord.
Yes.
It is necessary to keep in mind that a claim for seniority is to be put forth within a reasonable period of time. In this context, we may refer to the decision of this court in PS Sadasiva Swami versus State of Tamil Nadu, wherein a two-judge bench has held thus. It is not that there is any period of limitation for the courts to exercise their powers under Article 226, nor is it that there can never be a case where the courts cannot interfere in a matter after the passage of certain length of time. But it would be a sound and wise exercise of discretion for the courts to refuse to exercise their extraordinary powers under Article 226 in the case of persons who do not approach it expeditiously for relief and who stand by and allow things to happen and then approach the court to put forward stale claims and try to unsettle settled matters. I'll stop here, my lord. Para 24, 25, 26, 27 are also relevant. So, my lord, by entertaining, if the claim of the petitioners is entertained, the settled position of seniority, which remained for the past several years, will be unsettled, my lord. As I have produced before your lordship, these are the notifications which are not contained in the pleadings. That compilation, my lord.
Which compilation?
I have produced it. This
Okay. This
some
compilation.
few pages.
Okay.
My lord, this notification, the first one, page 1, I have paginated it in the at the top of the page. This is respondent number 4. This is the notification for her further promotion to the JAG. Respondent number 4. And page 2 is the respondent number 5 to the JAG. And page 3, again JAG.
Who the respondents?
Respondent number, serial number 1 is respondent number 6. Serial number 2 is respondent number 7. And 3 is 8.
Okay.
And page 4. Respondent 9. Page 5, my lord. These serial numbers in order of, there are 2 tables. The first one, it concerns with the first one only. Serial number 1 to 9 are respondent 10, 11, 12, 10, 11, 12, 15, 16, 17, 18, 19 and 20. Page 7, my lord. Page 7, there are two tables. I'll start from the first one. Serial number 1 is respondent 21, 2 is 22, 3 is 23. And the second table, serial number 1 is respondent 6, 2 is 11, 4 is 40, 40, and 5 is 45.
Five is respondent.
45.
So serial number 3 is missed out, isn't it?
Yes, my lord.
This is not a party.
Not a party. And page 8. The bold letters, that is the name, Vanlal Tanpuya, is respondent 24. And Bimal Sompuangi is respondent 25. And page 9.
Yes.
Serial number 1 is 29, 2 is respondent 30, 3 is respondent 31. And page 10, my lord. Page 10 is respondent 32. And page 11, the last page. 1 is 33 and 2 is 34. To this extent, they had already been further promoted, my lord, to
Initially
JIG,
they were appointed as junior grade,
junior grade,
then promoted to senior grade,
senior grade.
thereafter to junior administrative grade.
Yes, my lord. So this much the seniority had become settled. This is why I am producing this, my lord.
Yes.
So, my lord, there is no illegality in interspacing the present petitioners with respondent 42 to 50, and there is no reason why they should be interspaced with respondents 4 to 12 by quashing or modifying the seniority list. This is my submission, my lord.
Similar thing in the other writ petition also.
Yes.
You are
Yes, it's similar thing,
you
similar
are
matter.
representing which respondents?
Private respondents.
All of them?
Yes. The stand will be the same, my lord.
No. How many of private respondents are there?
Forty-four.
You're for all of them.
Respondents 4 to 17, 20, 22, 23, 25, 26, 28, 29, 31 to 44.
So who's missing?
18 is missing. 19, 24, 27. 19, 18, 24 and 27, my lord. 18, 19, 24, 27, sorry. My lord, sorry, 18, 19, 21 also. 18, 19, 21, 24 and 27.
Okay.
Your Worship, I'll give a reply to my learned friend's submissions, Your Worship. First of all, with regard to the submission regarding belated action on the part of the
Mr. Malhotra,
yes.
MPSC is there. Let him also submit then. Yes, Mr.
Your Lordship, although MPC is a respondent number 3 in this writ petition, so there is no challenge to our conduct and any of our action in this writ petition. So MPSC conducted this examination as per our schedule. So we have our own schedule. We cannot give priority only to MCS. So there are some other examinations which were due also. So my lord, as of now, so allow me to make my submission at the last. So then depends on that. I might allow lordship may kindly allow me to make my submission.
No, but what submission do you have to make? Otherwise, you have not filed affidavit also.
That's why I would like to adopt the government submission or in the private respondent submission also
And there's no relief claimed against you also, isn't it?
against us. Exactly, lordship.
So basically, I think you are only a pro forma.
Exactly, lordship.
So, okay, then I'll hear Mr. Malhotra, his reply. Yes.
Your Worship, regarding the belated action of the petitioners in challenging the seniority list, if Your Lordship will kindly allow me to take Your Lordship to the first order passed in this case,
Which case?
127 of 2019.
Hmm.
20th of September 2019.
Yes.
The first paragraph. Heard Mr. A.R. Malhotra, learned counsel for the petitioners who submit that the petitioners are agreed with the interstate seniority list of junior grade of MCS, published by notification dated 4/9/15, Annexure 17, and the final interstate seniority list of junior grade of MCS, published by notification dated 21/6/2018. This 4/9/2015 was published, but then after this, two other provisional seniority lists were issued. And then the final seniority list was again issued on 21/6/2018. So we have challenged the final seniority list dated 21/6/2018, in fact, within 1 year. Because although the 4/9/2015 list came, subsequently there were two provisional seniority lists issued.
When was it issued? It was issued in 2017.
No, Your Worship.
Final is 4/9/15.
Yes. After that,
As per your annexure 18, it's
Yes.
3/10/17.
Your Worship, Annexure 17, 4/9/2015 was issued. Thereafter, 3/10/2017, provisional was issued, page 69.
Yes.
3/10/2017 was issued, provisional. Then again, page 73, 24th April 2018, another provisional was issued. Then, lastly, page 77, 21/6/2018 was issued.
See, between 15 and 16, good 2 years had passed. 15 was a final list,
Yes.
and
Then provisional.
provisional came up again in 2017
17.
after 2 years.
Yes. So, I mean, the question was again opened. I mean, then after 2 years, the seniority was again, the provisional again came out. And any officer feeling aggrieved in this regard may submit his representation. Again, representations were called for in 2017. Then again in 2018, April also. Again, a provisional was issued. Again, representations were called for. Then 2018, June.
Okay.
So, and Your Lordship will see in the order dated 20th September 2019, if Your Lordship will see the last paragraph. Mary,
Yes.
having regard to the projection made by the petitioners, any promotion made to the next higher grade in the MCS on the basis of the impugned seniority list will be subject to the outcome of this writ petition. So, Your Worship, in spite of this order, the state respondents had carried on making promotions. at their own risk by utilizing this impugned seniority list. So the protection was already granted to the petitioners that any promotion made to the next higher grade on the basis of the impugned seniority will be subject to the outcome of this petition. So they cannot say that this is a settled position. In fact, if your lordship will see, most of these promotions are on officiating basis, not on regular basis. So, I mean, just because these promotion orders have been issued by the state respondents in the meantime, this does not prove that that is a settled matter and the seniority cannot be challenged. Because at the time of issuing notice, this Honorable Court had already held that any promotions made to the next higher grade on basis of the impugned seniority list will be subject to the outcome of this writ petition.
That is why they made it officiating over.
Yes.
But except for this promotion of respondent numbers 21, 22, 23, 6, 11, 40, 45,
Yes.
wherein there's no mention about
But again,
officiating.
this will be subject to the outcome of the writ petition. Because this is after the order was passed by this Honorable Court on 20th of September 2019. And Your Worship, my learned friend had cited the case reported in 2023 SCC Online, SC 1140, para 35. If two judgments are in conflict, then the earlier one has to be followed, para 35. So in our case, if that is the law laid down by the Supreme Court, Subba Reddy's case came much before Megha Chandra's judgment. They have the same strength, three normal judges. Subba Reddy came before Megha Chandra. So the law laid down in Subba Reddy has to be followed.
Apart from the Constitution bench.
Yes, apart from the Constitution bench. And then if we go further, Mervyn Cotino is by a Constitution bench. That will be binding on all of us then.
But why did they refer it?
They referred it because Your Worship, Hariharan was a bench consisting of only two judges.
No, that case. Regarding Megh Chandra case overruling the Palmer's case.
Yes.
The subsequent, what's his name?
Hariharan.
Huh?
Hariharan.
Hariharan.
Yes. Hariharan, Your Worship, was a bench consisting of only two judges. That's why they could not overrule Megha Chandra. So that is why they referred it to a larger bench.
Okay.
Megha Chandra was three honorable judges and Hariharan was honorable two judges bench. So since they could not overrule Megha Chandra, but they did not agree with the judgment in Megha Chandra, since they had not considered Subba Reddy's case and Mervyn Cotino's case, they referred it to a larger bench. If Hariharan's case was considered by three honorable judges of the apex court, then they could have easily overruled it. But since they were a smaller bench.
No, even with three also, how can they overrule?
Yes.
It will be a coordinate bench.
It has to go to a larger bench.
It has to go to a larger bench anyway.
So anyway, my learned friend has relied on para 35 of this Supreme Court judgment 2023 SCC Online, SC 1140. Then according to his own submission, the judgment in Subba Reddy will apply. And apart from that, Constitution bench, the judgment in Mervyn Cotino will have to be applied. Rotation of vacancies, rotation of water.
You are claiming your consideration from which date? 2010?
The requisition was initiated on the same date.
Correct, but they themselves have not got that benefit. The private respondents.
No, we are saying that since the requisition was initiated on the same date, the 10 direct recruits who were appointed on the basis of that 9th August 2010
10.
Requisition, our seniority should be interspaced with them.
Okay. Not that you want your,
Not that
your
we are
seniority
saying,
to be reckoned from 2010.
No. We are saying that our seniority should be interspaced with those 10 recruits.
Because they themselves were appointed in 2012.
Yes. So our claim is that our seniority should be interspaced with them, not that our seniority should be counted from 9/8/2010. It is just that our seniority should be interspaced with them, not with the direct recruits of January 2015. In fact, they were appointed as per the 2012 recruitment rules. We were inducted as per the 2002 MCS rules.
Only difference is the number of reservations
Yes.
for direct and promotees, isn't it?
Yes.
It has come down to, scale down to 20%.
And that also only Group A. And my learned friend had tried to impress upon your lordship that K. Megachandra's case has to be applied to the facts of the present case. But we have already said that, and it is an admitted fact, K. Megachandra's case has been to be applied prospectively, as directed by the Honorable Supreme Court in the said case itself, that this case will apply only prospectively. And it has not overruled NR Parma retrospectively. So only those cases after November 2019 will have to be applied according to Megachandra, but that also now is questionable because Megachandra's judgment has been referred to a larger bench. But in our case, our submission is that NR Parma's case will apply to our case because the seniority list challenged by us is 2015 and 2018. And at that time, it was NR Parma's case which was holding the field. And based on NR Parma's case, the OM of 4/3/2014 was issued by the central government. And it is an admitted fact on the part of the state respondents that they have no seniority rules. They are applying the office memorandums issued by the government of India. So, and if we go according to the OM dated 4/3/2014, then they cannot read para 5E in isolation. It has to be read together as a whole. 5E, A, B, C, D, E, F, everything. And somehow or the other, they are trying to overlook 5F, which clearly states that 5F, page 118 of the writ petition. The initiation of recruitment process for any of the modes with direct recruitment or promotion would be deemed to be the initiation of recruitment process for other modes as well. So they are trying to somehow overlook this provision, but it is very clear. It has to be read together with E also. So it is very clear that nowhere is it mentioned that seniority will be counted or initiation of recruitment processes will be counted only from the date of submission of ACRs, which they are trying to somehow convince the normal court that complete in all respects means submission of ACRs. But that is nowhere to be read in this OM dated 4/3/2014. Even in the case of a direct recruitment process, a requisition goes, advertisement has to be issued, applications have to be submitted. So that doesn't mean that the process shall be initiated, will be taken to be initiated only from the date of the examination or the interview.
The petitioners have not earned any promotion during the pendency of the petition.
Lordship, I'm not very sure. Yep, they have been promoted to senior grade.
Senior grade.
But I would like to confirm that. And if I may take your lordship to Hariharan's judgment,
Hariharan.
Yes.
There's one singer, Hariharan. Huh? Is it Hari Haran? No, Hari. Something, not Haran, Hari, something like that. Yes.
If your lordship will allow me to read para 5. The facts in this case, Hariharan's case. On 26 June 2009, the Chief Commissioner of Income Tax, Ahmedabad, filled in 53 posts of income tax inspectors by promotion on the recommendation of the DPC. So, 26 June 2009, 53 posts were already filled up by way of promotion. By communication dated 20th November 2009, Chief Commissioner of Income Tax forwarded a requisition for making appointment to 46 direct posts. So even in this case, the requisition was not sent on the same date. The requisition for direct recruitment was sent after the promotees were promoted. The requisition for direct recruitment was sent only on 20th November 2009. Promotions took place on 26 June 2009. But in spite of this, although requisitions were not sent on the same date for promotion and direct recruitment, the Honorable Supreme Court held that no, they have to be interspaced because rotation of quota is applicable.
That was as per the rules?
Pardon me?
As per the rules?
As per the rules, it is 50% direct, 50% promotee.
In this Hariharan's case?
In this, yes. Inspector of Taxes in NR Panda, Hariharan also. So this was a case regarding seniority dispute between promotees and direct recruits. As for the rules, 50% is by direct recruitment, 50% is by promotion. So even what I'm trying to stress on your chip is that in this case, promotion took place before even the requisition was sent for direct recruitment. But the Honorable Supreme Court held that they have to be interspaced. In our case, we are one step better. Requisition was sent on the same day. But due to the arbitrary action of the state respondents, they cancelled the requisition for promotion. But we challenged it in the High Court, and the High Court said, you have to continue with the process. My learned friend, while submitting, he had said that the process for induction was initiated again. That is a wrong statement, Your Worship. There was no fresh initiation for induction made by the state respondents. The initial requisition of 9/8/2010 was continued on the basis of the judgment of this Honorable Court.
Okay, where's that 50% direct, 50% promotion in this Hariharan?
In this Hariharan, para 4, yeah.
Oh,
Sorry, it is 2:1, Your Worship. Sorry, not 50-50, para 4. Two is to 1.
similar to the present case.
Yes.
Is it? It's 1/3.
Yes. My learned friend had submitted that after the judgment of the Honorable Court in WPC 127 of 2013, the requisition was initiated again for induction. But that is a wrong statement because, Your Worship, there was no fresh requisition for induction. The Honorable High Court had set aside the cancellation of the requisition process and it was resumed thereafter. And in fact, like I submitted a letter to Your Lordship.
Yes, what is this?
If I may read this, Your Honor. This is from the MPSC written to the GPNR secretary.
You had produced this the
Yes,
other day
I had
also.
produced this the other day, Your Lordship. This very well proves that the requisition was not a fresh requisition, but it was a continuation of the earlier requisition.
Okay.
And this letter which is referred to, reference number so-and-so dated 9/9/2014, is available in the affidavit filed by the State, Your Lordship, at page 20. In the affidavit filed by the State at page 20, this is also very relevant. Your Lordship. 20. If I may read this.
Yes.
To the Secretary MPSC, submission of notification of vacancies, invitation of willingness from other services for induction into junior grade of MCS. Regarding, I am delighted to inform you that in compliance with the Honorable Guwahati High Court judgment and order dated 23/7/2014 in WPC 127 of 2013, Government of Mizoram has decided to fill up 5 vacant posts of junior grade MCS by induction from other eligible officers in accordance with MCS Amendment Rules 2002. I am therefore directed to request you to invite willingness from other services accordingly for induction to the junior grade of MCS. In this connection, the prescribed form of notification of vacancies to MPSC duly filled in is enclosed herewith for favor of necessary action. So this letter replied by the MPC is very important, Your Lordship. If I may read this reply given by the MPC. Shall I read it?
Yes.
In inviting a reference to the subject and letter number mentioned above, I am directed to convey observation of MPSC with regard to the notification/proposal of the government under reference concerning induction into junior grade of MCS as per MCS Rules 2002 and the judgment and order of the Guwahati High Court dated 23/7/14 in WPC 127 of 2013. Since the Commission has already notified the government's requisition for induction into junior grade of MCS, inviting willingness from eligible interested officers of the government of as per MCS Amendment Rules 2002, white letter number so-and-so dated 19/11/2010, which is exactly in conformity with the requisition of the concerned department, white letter number 9/8/2010. The Commission is of the opinion that issuing fresh notification, inviting fresh willingness for the purpose mentioned in your letter doesn't correspond to the proper norms of recruitment to any post of the government, nor does it augur well with the judgment of the Guwahati High Court. In fact, way back in 2011, Commission had already received and verified 53 willingness, out of which 41 willingness were accepted as valid applications. Hence, the Commission sees no justification for inviting fresh willingness for the stated purpose as it had been done as per MCS Amendment Rules 2002 back in 2010, which is also in accordance with judgment of the Honorable High Court. So, Your Worship, this was a continuation of the requisition issued on 9/8/2010. It was not a fresh requisition. But my learned friend in his submission had said that it was a fresh requisition. Process was initiated again. And Your Worship, regarding my learned friend's belated claim being filed by the petitioners, that's beyond their pleadings. Even in their affidavit, if I'm not mistaken, they have not taken that stand in the affidavit filed by them that the writ petition is liable to be dismissed as it is a stale claim. And with regard to that, Your Worship, if I may be allowed to submit some citations tomorrow
Regarding?
belated claim, which my learned friend has subsequently submitted now, in spite of not having stated it
Yeah,
in the
surely. Keeping it for tomorrow because
Yes.
government advocate expects some difficulty.
difficulty.
That's why. Yes. That's it.
That's
Mr. Jesse, you want to say anything?
No, no, my lord.
Call the steno.
Right, Your Lordship, all the petitioners have been promoted to senior grade
Senior grade.
after filing of the petition.
Any JG?
No,
JG.
not yet.
Please come forward. Okay, take the files. You just retain the books. It's okay. The learned counsels for the parties have made their made their submission, except for the learned government advocate. So as such, list the matter again tomorrow for hearing as part